Hello, dear students. Welcome back to my class of Company Law and Secretarial Practice. So in this class, let's deal with what are the types of companies. So I'm Dr. Indraini Katti, associated with Karnataka Arts and Commerce College, Dharwad. Okay. So let's deal with this. It is a very interesting topic. What are the varieties of or types of companies, and which is very important from the examination as well as from the knowledge sake. So that's why stay till the end. Okay. So let's classify the companies. Main category, 5 types we can categorize the companies. That is based on the incorporation, based on liability, based on the number of members, and based on the control, and based on the ownership. Okay. So when we take into consideration based on the incorporation, 2 types of incorporations are made. That is statutory companies and registered companies. Based on the liability, these are also limited liability companies are also there, and unlimited liability. And based on the numbers, that is OPC company, one-person company, private company, and public company. So likewise, we can learn here. And based on the control, a holding company which controls the subsidiary, right? And subsidiary company is controlled by the holding company. So what are all this? And based on the ownership, government company and foreign company. So let's learn one after one. So on the basis, first one, let's learn what do you mean by statutory companies. Here, in this type, you will get at least, 2 marks questions will be covered in this. And if a question is a lengthy question, and you will get a 10 marks question also on this types of companies, right? So here the question may be for 2 marks, statutory company may be asked, or registered company, private limited company means what, public limited company, or a limited liability and unlimited liability. So based on all this, that's why this chart is very, very important from the examination point of view, as well as from knowledge, right? Okay, let's move on to the statutory company. These are all the companies which are created by a special act, right? So act is passed in the parliament. Okay, so special act of the legislature. That is, in India, we do have RBI is also a company, SBI is a company, ITBI, GIC, UTI, Unit Trust of India, GIC is General Insurance Corporation of India, LIC is Life Insurance Corporation of India. See, all these companies are the examples of statutory company where these companies have got their own acts. Okay, so ಕಾಯ್ದೆ ಪ್ರಕಾರ ಇವನ್ನೆಲ್ಲ ಫಾರ್ಮ್ ಮಾಡಿದ್ದಿದೆ. Act is passed in the parliament, then these companies are established. Okay, and these are mostly concerned with public utilities as railways, tramways, gas and electricity companies, and enterprises and of national level importance, right? So along with these, to render, main motto is to render the services to the public. Okay, so that's why these companies are, especially by passing a special act, these companies are formed. Okay. Now, what are the features of statutory company? These are incorporated by special bills or acts in the parliament, and separate legal entity. These have got a separate legal entity which are separated from the owners, and state control, that is government is going to control the affairs of all these companies, and nominated directors of the government will be there in the board of directors, and service motive. The main purpose is not to earn the profit, but render the services to the public. So let's move on to the next, the second kind, that is registered company. One is statutory company, you have learned, and second one is registered company. So these are all the companies which are formed and registered under the Companies Act, either 1956 Act or the Companies Act 2013, So features of these registered companies, these are all incorporated companies. It means registration is compulsory for establishing the registered companies under the Companies Act 1956 or under the Companies Act 2013. Those companies will have to register themselves. Okay, and disclosure and formalities. So a lot of annual disclosures will be there. The documentation is to be made with the ROC, that is Registrar of Companies. Okay, a lot of formalities are there to establish these companies, and these will be having limited liability. These are not unlimited companies, but these registered companies in India, we have only limited liability companies. The liability of such companies is limited. It means the owner's liability is limited towards the investment. Whatever the unpaid amount is there, unpaid share amount is there, only to that extent they are held responsible. For the loss of the organization, no owner is held responsible. Okay, that's why we call it as limited liability. And easy transferability of shares will be there. If a public company limited is there, then the shares are easily transferred. Okay. See, this image is of Ministry of Corporate Affairs. So let me take you for a few minutes or few seconds to the website only, which is called as Ministry of Corporate Affairs, right? So this is the website, Ministry of Corporate Affairs. Here, lot of information you will get here related to the companies in India. So here under the MCA services, the short form of this MCA, Ministry of Corporate Affairs, we call it as, and MCA services, if you go here, we will get these relations in relation with these companies, company services. If you go to company services, go to here, incorporation. So the information related to the incorporation of a company, that is all. We get lot of information in this website if you visit it. Okay. See, steps to register a new company. If you wish to register a new company that is registered under the 2013 Act, Companies Act 2013. If you would like to establish a company, how can I register an Indian company? And there is a space for the foreign companies also, how can foreign companies establish a place of a business in India? So what are the formalities? What are the steps involved in the incorporation of a company or registration of a company? All details are available on this website itself. So a lot of information, not just a single thing, but a lot of information is available. That's why you can go to this also, right? So visiting this website will enrich you. That's why, being the students of company law and secretarial practice, do visit this website and browse it. Okay. So let me move on to the next slide, which is related to on the basis of, we are categorizing the companies on the basis of liability. So first company is called as limited liability. So under the companies which are having limited liability, under this we learn two types, that is limited by shares. Another one is limited by guarantee also. Okay. So let's learn, what do you mean by limited by shares? Section 2, subsection 22 of Companies Act. Company limited by shares means what? A company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. That's why I told liability is limited. The owner's liability is limited towards the amount which is unpaid, which is remained unpaid on the share value, right? Share amount, if you have not yet paid completely at that time, to that extent, the owner is going to held liable. Okay. And if the shares are fully paid, the liability of the members holding such shares is nil, no liability at all. Okay. It may be a public company limited or a private company limited, but the liability is limited. Okay. The members' liability is limited. The owner's liability is limited. So such companies, we call them as limited by shares. Okay. Let's move on to the next one, that is limited by guarantee. That is section 2 and subsection 21 of Companies Act 2013 explains it. What is this? It means a company having a limited liability, a company having a liability of its members limited by the memorandum to such an amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. It means at the time of liquidation of a company, when a company is going to be wind up, right? When you are going to close the shutters of such company, at that time, the members of the company, okay, in memorandum, they specify certain sum of money. They are held responsible for the payment of that amount. Okay. So such amount is specified in the memorandum itself, right? Limited by the memorandum to such amount as members may respectively undertake to contribute. They have promised over there that they are going to contribute certain sum of money at the time of winding up of a company, right? Such company is known as a company which is limited by guarantee. Guarantee is assured by the members of such company related to the loss of the organization. They are going to bear the loss, certain sum of money they are going to bear as their liability. Okay. So let's move on to the next one. These companies are not formed for the purpose of profit, but for promotion of art, science, charity, sports, or for some similar purposes. Okay. These companies are not for profit, but they are for the services or to develop the art and science. Charity organizations will be there, sports development organizations will be there. So such all organizations can be formed under the Companies Act only, but limited by guarantee concept will be introduced. So let's move on to the next one, that is companies with unlimited liability. Okay. Section 2, subsection 92 of Companies Act 2013 says, what do you mean by unlimited? Okay. Unlimited company means a company not having any limit on the liability of its members. It means the liability of the members is unlimited. At the time of loss which is caused to the company, that is all will be borne by the members of the organization. Okay. A company without limited liability is called as unlimited liability. Every member is liable for the debts of the company, and an unlimited company may or may not have a share capital. If it has a share capital, it may be a public company or a private company. It must have its own articles of association. But in India, we don't find such companies, that companies with unlimited liability, we don't find. Okay. So now let's move on to the next one, that is third category of classification on the basis of number of members. We can categorize the companies on the basis of number of members as a private company. Okay. What do you mean by private company? Let's look at the definition which is explained in section 2, subsection 68. Okay. A private company means a company having a minimum paid up share capital as may be prescribed and which by its articles. It means here they have not given a particular amount as a minimum paid up share capital, right? It may be prescribed from time to time. In its articles, it will be prescribed, okay? And the very important thing, private company restricts the right to transfer its shares. It means the private company shares cannot be transferred from one person to another person. Only public company limited shares can be easily transferred, but not the private company shares. Okay, that's why a private company restricts the right to transfer its shares. And second one, private company, except in case of one-person company, that is OPC, we call it does. Okay, one-person company limits the number of its members to 200. Okay, it means except this, in one-person company, the member will be a single person. Except this, it means one-person company is also part of private company limited only. And private company limited, the maximum number limit is 200. Okay, right? It begins, minimum will be 2 and maximum will be 200. Provided that where 2 or more persons hold 1 or more shares in a company jointly, or they shall for the purpose of this clause be treated as a single member. It means in single person's name, if 2 or more than 2 persons hold more number of shares, at that time we cannot count it by number of shares, but we will count it by lives. Okay, so that's why single person, we'll have to consider him as a single member only. Provided further, a person who are in the employment of a company and persons who are having been formerly in the employment of the company, were members of the company while in that employment and have continued to be the members after the employment ceased, shall not be included in the number of members. It means what? Sometimes the companies distribute the shares to their employees. Okay, so ESOP, you might have heard it. Employees will get the shares from the company in that. Instead of getting the bonus in the form of cash, some companies distribute the number of shares to them. But such companies, members who are the employees of such company cannot be treated as members if they are in the employment or out of the employment also. But if they hold such shares, they are not called as members. Okay, and it prohibits any invitation to public to subscribe for any securities of the company. It means what? In short, what you can say is a private company restrict the transfer of shares from one person to another person. And the private company membership maximum limit is 200. And coming to the third one, it prohibits the invitation to public. It means it will not offer any shares to public to subscribe towards the share capital. They will be having their own group and they only contribute and they will become the owners of the company. Okay, this is all about private company limited. Let's move on to the public company limited, right? Section 2, subsection 71 of Companies Act 2013 defines a public company means a company which is not a private company. See, in the meaning, how it has been defined, a public company is not a private company, first condition, and has a minimum paid up share capital as may be prescribed. It means here also the amount of paid up share capital is not prescribed, because from time to time it goes on changing. That's why it is mentioned over there only, but the amount is not stated in the definition. Okay. So provided that a company which is a subsidiary of a company, not being a private company, should be deemed to be the public company. It means what? Provided that if a public company limited is having a subsidiary company, but it is a private company, this is also should be deemed to be treated as a public company for the purpose of this act, even where such a subsidiary company continues to be a private one, right? That subsidiary company is a private company, but if it is a subsidiary of a public company limited, then that subsidiary company is also considered in this act as a public limited, even then it is a private company. Okay. Well, some exemptions and privileges, some privileges are exercised by the private company. What are those? Private company has got some privileges. It can have a minimum of 2 members. Only with the 2 members you can begin a private company, right? Second one, it can commence business immediately after obtaining the certificate of incorporation. See, this is the second stage in the promotion of a company. First one is promotion stage. In the formation of a company, we have different stages, 4 stages we have, right? Promotion stage. Second one is incorporation stage. Only after getting the certificate of incorporation from the registrar, a business can be commenced if it is a private company limited. Okay. And no need to issue any prospectus or a statement in lieu of prospectus. No need to prepare any prospectus or statement in lieu of prospectus for a private company. If it is a public, then you will have to prepare, right? It can have a minimum number of directors. How many? 2. At least. Minimum number of directors is 2 for private company. If it is OPC, 1. Okay. So it need not hold a statutory meeting or file a statutory report with the registrar also. With the ROC, registrar of companies, this company, private company, need not submit any statutory report, or it need not hold any statutory meeting. Statutory meeting is a first important meeting of a company, okay, in its lifetime. Only once it is held. Okay, so there is no condition for private limited company. And this is the next classification, that is on the basis of control. One is called as holding company, the other one is called as subsidiary company. Okay, what do you mean by holding company? Let's understand. A company is known as the holding company of another company if it has the control over that of other company. It means the board of directors will be from the holding company only. The control and the management will be done by holding company, but it has another company's control. Okay, so the another company itself is called as subsidiary company, right? A holding company is a parent company that has control over a subsidiary company, right? So what do you mean by subsidiary company? No. Let's understand. A company is known as a subsidiary of another company when control is exercised by the holding company, right? It means subsidiary company will be managed, controlled by holding company. Okay, a subsidiary company may be for profit or for non-profit. It means it may be a profit organization, or it may be rendering services, having service motto. Okay, a parent subsidiary relationship has a legal and financial implications for both the companies. There is a benefit, legal benefit will also be there, and financial implications will also be there for both the companies, that is for holding company as well as for the subsidiary company. Let's take an example here, holding or subsidiary company. Let's understand this. A company, if the other company controls composition of its board of directors, okay, the other company holds more than 50% of the nominal value of its equity capital, second condition. And the third condition, the first mentioned company is a subsidiary of any company which is that other's subsidiary. It means for this line, I will give you an example, right? So first two, you might have understood. Holding company will be having the composition of board of directors of a subsidiary company, and the other company holds more than, it means holding company will be having more than 50% of the nominal stake of the subsidiary company, right? Third one, let's understand the meaning of third sentence with this example. As you may be knowing, the company, Indian Rayon Industries Limited, is a subsidiary of Grasim Industries, right? Aditya Birla, you have heard the name of Aditya Birlas, right? So these are the industries of Aditya Birla only, okay? So Indian Rayon Industries Limited is a subsidiary of Grasim Industries Limited, and the Ultratech is a subsidiary of Indian Rayon, right? So this Indian Rayon is a subsidiary of Grasim. It means what? Holding company is Grasim Industries Limited. And Grasim Industries Limited is having a subsidiary company which is named as Indian Rayon Industries Limited. Okay. And this Indian Rayon Industries Limited has a subsidiary company that is called as Ultratech. Okay. Ultratech, which produces cement, right? Ultratech company is a subsidiary of Indian Rayon. So, company Ultratech is also called as a subsidiary of Grasim. Got an idea, right? So the third sentence meaning is the same one. Okay. So here you understood what is holding company and what do you mean by subsidiary company. Let's move on to the next classification on the basis of ownership. Okay. So we have two categorization on the basis of ownership, that is government ownership and the foreign company ownership. Okay. So government company, which company do we call it as a government company? Section 2, subsection 45 of the Companies Act 2013 defines a government company means any company in which not less than 51% of the paid up share capital is held by, right? It is any company, government company is any company in which not less than 51% of the paid up share capital is held by whom? Either the central government or the state government or the governments, different state governments, or partly by the central government and partly by one or more state governments, and includes a company which is a subsidiary company of such a government company, right? Understood, I hope. Okay. What is government company? You understood. The stake is more than 51% of the paid up share capital, right? And the stake is held by whom? Either central government or either state government. One state government may be there, or so many state governments may be there, many, two or more than two state governments may be there, or partly by the state government, partly by the central government, and some other state governments also may be there, right? Or else, which is a subsidiary company of state government. Okay. Sorry, government, maybe central or state government company is there. So that other subsidiary company is there. That subsidiary company will also become a government company. Okay. So let's move on to the foreign company. What is foreign company? Section 2, subsection 42 defines a foreign company means any company or body corporate incorporated outside India and which, right, outside India, it is registered outside India and which has a place of business in India, whether by itself or through an agent, physically or through an electronic mode, right? It means actually you will have to understand that this is a body corporate which is registered, which is incorporated outside India. This is very important. Okay. So foreign company is incorporated outside India, but it is in India. It is having its business in India, whether by itself or through an agent or physically or through electronic mode also. Okay. So they are all called as foreign companies. And in conducts any business activity in India in any other manner. Okay. Apart from these above mentioned, in any other manner, if it conducts activity, business activity in India, then also we call thus such company as a foreign company. Here we conclude the discussions of all the different types of companies, and I hope all of you understood. Feel free to express your feelings or your comments in the comment box. Thank you very much.